Alright, Section 501c3 Organization. Introduction. An organization may qualify exemption for the federal income tax organized for the operative exclusively for one of the following purposes: religious, charitable, scientific testing, public safety, literary, education, fostering national, international, amateur sport competitions, but not only if none of the activities involving providing athletic facility or if none of its activities involve providing athletic facilities or equipment. However, athletic organization later a chapter of the prevention of cruelty to children and animals qualified organization must be a corporation committee each has funds the article of the association foundation trust and fund but the trust is a fund or foundation will qualify. However, individually a partnership won't qualify. Example: qualifying organizations include nonprofit old age homes, parent teacher association, charitable hospital, other charitable organization, alumni association, schools, chapters by Red Cross, boys and girls clubs, ordering churches. The child care organization. The term educational purposes include the providing of the care of the children all away from their homes and substantially all the care provided with enable the individuals, the parents to gain employed of the service available to the general public. Instrumental. A state municipal instrumentally may qualify under Section 501c if organized separated with the intent of the government until the created within an otherwise immediately organizational operational test of the Section 501c3. Example: the qualifying instrumental might include state schools, universities, hospitals. However, if the organization is an integral part of local government, possesses governmental powers, it does not qualify to tax for exemption. State municipality still does not qualify exemption. Topics. Chapter of discussion. Contribution with the 501c3 organization. Application for recognition for the exemption. Articles of organization. Educational organization. Private and school organization providing insurance. Other Section 501c organization. Private funds and public charities and lobbying expenditures. Useful items. You may want to see Forms 1023 Application for Recognition Exemption under Section 501c3 Internal Revenue Code and 1023 EZ Streamlined Application for the Recognition Exemption under Section 501c3 Internal Revenue Code. Section 6 Information about getting publication forms. Contribution 501c3 Organization. Or a contribution to domestic organizations described in the chapter that exempt the organization testing the public safety deductibility of charitable contributions, donors, federal income taxes, return fundraising events, and if donor received something value in return for the contribution, common occurrence for the fundraising after the party for all contribution may not be deductible if may apply for the fundraising after each has charitable balls, bazaar, banquets, auctions, concerts, athletic events, solicitation member of the contribution with the member. Merchandise benefits that are given in return for the payment of the specified minimum contribution. If the donor expects to receive the goods and services returned with the contribution, your organization, the donor can deduct any part of the contribution unless the donor intends to do or does make a payment greater than the fair market value of the good of the good or services. If the deduction is allowed, the donor can deduct any of the part of the contribution, any of the more of the fair market value of the goods and services received. You should determine the advance of the fair market value of any of the goods and services given the contribution. Tell them the public side of the funding of the events for the solicitation. So with the contributions and how much of the deductible, how much of the gift for the services, see the disclosure for the quid pro quo contribution in Chapter 2. Exemption application not filed. Generally, donors cannot deduct any charitable contribution to organize that is required to apply for the recognition exemption that has not been done so. Separate fund contribution and deductibility. An organization exempt from the federal income tax other than the organization described in Section 501c3 if the desired established fund is separate from the pair of the other funds exclusively with religious, charitable, scientific, literary, educational purposes, fostering national, international, amateur sports competition for the prevention of the cruelty of the children of animals. If it is a fund organized operated with exclusively these purposes, must be qualified exemption with the organized described in Section 501c3. Contributions made, it will be deductible provided with the Section 170. A fund with the characteristics must be organized such a manner prohibited the use of the funds and use of the dissolution, otherwise for the general purpose of the organization creating it. Alright, personal benefit contracts. Generally, the charitable deductions won't be allowed to transfer to use or for use of Section 501c3 or C4 organization in connection with the transfer. The organization directly and indirectly paid the previously paid premium on the personal benefit contract for the transfer. There is an understanding with the expectation that anyone directly and indirectly pay with the premium the personal benefit the contract for the transfer. The personal benefit of the contract will respect the transfer and the annual life insurance, annuity, and contract in the direct and indirect beneficiary under the contract of the transfer, any member of the transfer family, any of the other persons designated with the transfer. certain annuity of the contract. If the organization incurred with the obligation to pay the charitable gift of the organization purchased for the annuity of the contract fund with the obligation the individuals receiving the payment under the charitable gift annuity won't be treated with indirect beneficiaries if the organization owned all the incentives for the organization under the contract entitled to all the payments under the contract. The timing and the amount of the payment is substantially the same with the time and amount of the payment to each of the person under the obligation, such as the obligation effective at the time of the transfer. C. Certain contracts held with the charitable remainder of the trust, an individual working on the consider the indirect beneficiary under the life insurance annuity, the indirect contract held with the charitable remainder in the annuity trust and charitable remainder on a unity trust solely reaching for the being entitled with the payment if the trust owns all incidents of ownership under the contract of the trust entitled with all the payments under the contract. Excise tax if the premiums are paid with the connection with the transfer to which the deduction is allowable. The deduction deniable rule without regarding whether the transfer charitable organization was made with the excise the tax applied with the equal the amount of the premiums paid with the organization any life of the insurance annuity and dormant contract of the excise tax does not apply with the direct and the indirect beneficiaries under the contract organization. Excise tax is a charitable organization liable for the excise taxes must perform the 4720 for the return of the certain excise taxes under the Chapter 41 and 42 for the Internal Revenue Code, generally due date of the filing form of the 4720 with the occurs on the 15th day of the filing month following the closing of the organizational tax year. Indoor tanning service. The organization provides the indoor tanning bed service. The ACA imposed the 10% excise tax on services provided on June 30th, 2010. For more information, then go to the IRS Gov. Select Affordable Care of the Tax Act provisions. Application for recognition of the exemption. The discussion describing the certain information that provide the application for the recognition for the exemption organization created for the name of the person described earlier with the chapter. For example, the application must include the confirmed copy of the organization articles of incorporation that discuss the articles in organization. Later in this chapter, the organization held headings of the following specific information for the organization may need to provide. Form 1023. The organization filed for the application of the recognition exemption with the Form 1023. See Chapter 1 with the instruction accompanying with the Form 1023. The procedure following and applying with the same organizations that are required to file the 1023. See organization not required to file Form 1023 later. If the small organization, you can save the time and the money filing the Form 1023 easy instead of the Form 1023. You can find more information on the filing of the Form Instruction Form 1023 easy. Additional information to help you to complete the application can be found online. Go to the exemption requirement of 501c3 organization. Select the link at the bottom of the webpage. Step to help the application process. See exemption requirement section 501c3 organization. The 1023 accompanying the statement must show that the following rates are are all true. The organization organized exclusively for and operated exclusively for one or more of the purposes of religious, charitable, specified introduction of the chapter. No part of the organization net earnings will inure the benefit of the private shareholder individual. You must establish the organization. You won't be organized operated with the benefit of the private interest in such creative the creators, the family shareholders, or the organization, other designated individuals, persons controlled directly and indirectly such private interests. And 3. Organization won't or a substantial part of the activities attempt to influence legislation unless it elects to come in under the provision allowing certain lobbying expenditures, participate in extent of the political campaign or for and against the candidate for public office. See political activity next and lobbying expenditures near the end of the chapter. Alright, political activity. If any of the activities, whether or not substantial for the organization, consists of the partnership participating and intervening with the political campaign or behalf of the opposition to any of the candidate political office, the organization won't qualify to tax exempt status under the Section 501c3. The participation and intervention will include the publishing and distribution of the statements. Whether the organization participation and intervention directly and indirectly political campaign on behalf of or in position of any of the candidate or political office depends upon all factors of the circumstances of each of the case. For the certain voter education activities the public forums conducted with non-participation partisan manner may not be prohibited public activity under the Section 501c3, while other so-called voter education activities may be prohibited. Effective date exemption. Most exemptions described in the chapter of the organization after October 9, 1969 will be treated with tax exempt unless applied recognition exemption of the filing form 1023. These organization will be treated with the tax exempt in any of the period before the filing form of 1023 unless the file of the form 27th of the month from the end of the month with which they organize. If the organization files the application within 27th of the month, the organization exemption will be recognized retroactively. The date of the organized the exemption will be recognized only with the date of the receipt. The date of the receipt, the date of the U.S. postmark on the cover of the exemption application is applied if no postmark appears on the Cover the date of the application stamped as received by the IRS. Private delivery service. The private delivery service is designed by the IRS rather than U.S. Postal Service. Receive the delivery application the day of the receipt, the day of the record covered marked by the private delivery service. The following private delivery service has been designated by the IRS. DHL Express, DHL Express 9 a.m., DHL Express 10:30, DHL Express 12 p.m., DHL Express Worldwide, DHL Express Envelope, DHL Import Express 10:30, DHL Import Express 12 o'clock, DHL Import Express Worldwide. Federal Express First, Overnight Federal Express Priority, Overnight Federal Express Standard, Overnight Federal Express 2-day, Federal Express International Next Flight Out, Federal Express International Priority, Federal Express International First, Federal Express International Economy, U.S. Parasol Services, USP, UPS Next Day Early Morning, USP Next Day Air, USP Next Day Air Server Saver, USP Second Day Air, USPA Second Day Air AM, USPA. That's Worldwide Express and UPS Worldwide Express. Amendments to organizing documents required. If the organization required after the activity to make substantive amendments to organizing document, the ruling, the determination letter recognizes the exempt the status will effective as the day of the change are made. Though if an non-substantive amendment is made, the exempt status will be effective as of the day of the organization. The application was filed within the 15-month period of the day of the application was filed. Extension for the time of the filing. There are two ways for the organization seeking exemption that can receive the extension for the time of the following Form 1023. Alright, automatically 12 months extension organization will receive the automatic 12 months extension filing the application for the recognition of exemption from the IRS within 12 months of the original deadline. To get the extension, the organization must add the following statement at the top of the application filed pursuant to Section 301, 99102. Discretion extension for the organization failed to Form 1023 with the extend the 12-month period of the grant of the extension for the file to submit the evidence and including affidavit to establish if it acted upon reasonable good faith, the granting of the discretionary extension for the prejudices the interest of the government. How to show reasonable action with the good faith, the organization acted to reasonably show good faith, and at least one of the following is true. The organization requested the relief before its failure to file discovered by the IRS. The organization failed to file because of the intervening events beyond its control. 3. The organization exercised reasonable diligence, taking into account the complexity of the return issue of the organization experience within these matters, but wasn't aware of the following requirements. The organization reasonably relied upon written advice from the IRS. The organization reasonably relied upon advice of the qualified tax professional, failed to file an advice organization Form 1023. The organization can rely on the advance of the tax professional to know that and should know that he or she isn't compliant with the rendering advice of the filing expectation of the application that is not aware of all relevant facts. Not acting responsible in good faith. The organization is not acting responsibly in good faith under the following circumstances and seek the change, but the return position of the accuracy related penalty has been code imposed at the time of the relief. The requesting information with the requirement of the related tax consequences, but chose not to file, is used in hindsight with requesting relief of the IRS would only grant the extension for the specific task to change signs for the due date makes the filing application for the advantages to the organization. Alright, prejudicing the interest of the government. Prejudice into the interest of the government result with the granting extension for the time that is filed with the organization result with the lower total tax. It's for the years they which have the filling and applied with the have been paid for the organization that has been filed on time before the granting extension for the IRS can require organization requesting to submit the statement from an independent auditor certifying that no prejudice will result in the extension of the granted. The interest of the government and ordinary prejudice for the tax year, but the application should have been filed within any tax year that would have been effective with having the been timely and closed the statute of limitations before relief of the grant of the IRS condition of the grant with the relief of the organization provided by the IRS with the statement for independent auditor certifying the interests of the government aren't prejudiced. Procedures requiring extension of the request for the discretionary extension of the organization must submit the IRS address shown form 1023 or notice 1382 for the following. The statement showing the date of the form 1023 the required to have the date filed with the date actually filed. Any documents relevant to the application affidavit describing the detail of the events related failure to apply with the discovery of the failure of the organization relied with the tax professional advance affidavit must describe the engagement responsible for the professional extent with which the organization relied on him or her. The affidavit must be accompanied by the date of the declaration signed by the individual with personal knowledge of the facts and circumstances authorized by the act of the organization, which, under penalty for the perjury that I declare that I have examined the request, including the accompanying documents, and to the best of my knowledge, but have the request that contains all the relevant facts relating to the request, such as the facts are truly correct. Detailed affidavits and individual having knowledge of the information about the events that have led to the failure to make the application for the discovery of the failure. These include the organization return of the paper, the accounting with the return of the knowledge of the tax materials, advised taxpayer on the application for the affidavit is described in the engagement and enrollment, responsibility of the individual advice that she provided with the affidavit, he or she provided. The affidavits must include the name of the current taxpayer identification number of the individual to be accompanied with the date of the declaration signed by the individual state, which in states under penalties under penalty. Under penalties of perjury, I declare that I have examined the request and included the accompanying documents to the best of my knowledge on behalf of the request containing all the relevant facts relating to the request, such as the facts and true, correct, and complete. The organization must state whether the return of the tax year for the applicable litigation should be filed with the tax of the year that would have the effect for the application to be timely made with the exam of the IRS appeal for the federal court. The organization must notify the IRS office considering the request for relief of the IRS starts the examination of any such request and return for the organization request for relief is pending. The organization requested to submit the copy of the tax return, the copy of the returns of other affected taxpayers. The request for the relief to come in connection with the application for the exemption does not require the payment of the additional user fee. Also, the request for the relief of the automatic 12-month extension does not require the payment of the user fee. Alright, a request for relief in connection with the application exemption that does not require the payment of the additional user fee. The request for relief of the automatic 12 months extension does not require the payment of the user fee. For more information for the procedure to see the regulation, section 3019-100, 3019-9102, and 301-9103, revision procurement of 2017 5. Alright, notice from the IRS, the organization filing 1023 satisfying all the requirements of section 501c3 with the notified of the exempt status of the writing. Organization not required to file with the form of 1023. Some of the organization are required to file Form 1023 and 1023 EZ, but the insurance include inter-church for the organization, local units of the Church Convention for the association, church, integrated auxiliary churches such as the men's and the women's organization, religious church, religious school, missionary society, youth groups, any organization, other private foundation normally having the annual growth to receive no more than 5,000 see the gross receipts test, and any organization other than private foundation normally having an annual growth of not more than $5,000. The organization is exempt automatically meets the requirements of Section 513. C. Following Form 1023 exemption, establish exemption. If the organization wants to establish exemption from within the IRS receiving the ruling, the determination for the recognized exempt status, it should file with the 1023 EZ with the eligible establishing exemption potential contributors associated with the IRS contribution with a deducted subordinate organization other than the private foundation covered by the group extension letter does not meet. They have to submit with the 1023 itself. Private foundations. See private foundation public charities later for the charter chapter with more information with additional notes required for the organization order to not be presumed to provide foundation for additional information required for the private foundation claiming to be open or operating the foundation. Gross receipts and tests. For purposes of the gross receipt and test, organization normally does not have more than $5,000 annually if the gross receipt during the first tax year of the organization will receive the gross receipts of $7,500 or less. During the first 2 years of the organization will have a total of $12,000 or less of the gross receipt. In the case of the organization have been existing with the last 3 years of the total growth of the receipt received the organization described during immediate proceeding of the 2 years plus the current year of the $15,000 or less. Alright, any organization with gross receipts more than the amount of the gross receipt tested unless otherwise exempt with the filing Form 1023 must file with the 1023 within 90 days after the end of the period within the amount of the receipt of the example of the origination of the gross of the receipt of the first tax year with the less than that $7,500, but the end of the second year of the gross receipt the 2-year period were more than $1,200. $12,000. The organization must file with the Form 1023 within 90 days at the end of the second tax year. If the organization exists for at least 3 tax years and had gross receipts less tested than all prior to the tax years and fails to meet the requirement of the current tax year, tax exempt status the prior years won't be lost. Section 5013C organizations won't be lost even if the Form 1023 is filed within 90 days after the closing of the current tax year. However, the organization won't be treated with Section 5013C organization for the period being with the current tax year ending with the filing Form 1023. An organization organized and operated with exclusively charitable purposes, innocent private foundation and corporation with the January 1st, 2012 file with the return of the calendar year based. It did not follow the 1023 that organization growth received during the 2012 through 2012 to 15 were as follows: $3,600, $2,990 for 2013, $400, 2014, $1,260 for the 2015. The organization total gross received the 2012, 2014, 2014, $6,900. It did not have filed the Form 1023 with Exempt of those years. However, the 2013, 2014, 2015 total agrees for the 15,000. $900. Therefore, the organization must file with the 1023 within 90 days after the end of the tax 2015 tax year. If it does not file within the time period, it won't be exempt. It won't be exempt under Section 501c3 after the period of the beginning of the tax year 2015, ending up with the Form 1023 received by the IRS. The organization, however, won't lose its exempt status for the tax year ending before the January 1st, 2015. The IRS will consider applying this commission their discretion and authority to the extent of the filing of the Form 1023 to see the procedure extensively discussed earlier. Alright, Articles of Organization. Organization must include the confirmed copy of the Articles of Organization applicable to recognition of the exemption unless filing the Form 1023 easy but may be in the trust instrument, the corporate chart of the Articles of Association, and any of the written instrument which has been created with the organizational testing. Articles of Organization must limit the organizational purpose of the one or those described in the beginning with the chapter. Mustn't express in power to engage other with it, thus insubstantial the activities done further one or more purposes of these conditions exempt, and refer to the organizational test 501c3 provision of law of the grant exemption of the organization described in this chapter. Therefore, the organization test must be meet the proposed set of the articles in organization include and are limited to some way a reference to section 501c3. Or the requirement of your organization purpose of the power must be limited with the article of the organization satisfied the limits that contained only on the behalf by laws or other rules regulations. The moreover, the organizational test specified statement of the organizational officers intended to operate only with exempt purpose. Also, the test isn't satisfied by the fact of the actual operation for the exempt purpose. Interpretation of organizational articles of law of the statement the laws of organization was created with the control of the organizational content to determine the articles is different from the meaning or the state of the law generally accepted the meaning of such meaning must be established with a clear convincing reference of relevant court decisions or opinion of the state with the attorney general with the appropriate state authorities. The following example is illustrating the original test. The articles of the organization of the state with the organization conform with exclusively literally scientific purposes with the meaning of the section 501c of the articles appropriately limited to the organization purpose of the organization meet the organizational testing. Example 2. The organization without the terms of articles of form with engaged the research without the firm the description of limitation of the organization won't be properly limited to the purpose of all of the research within the scientific organization does not meet the organizational test. 6. Example 3. The organization articles of state purpose to receive the contribution to pay them over the organization description of section 501c3 of the example of the taxation under 501a of the organization meet the organizational test. Example 4. If the state purpose of the article to conduct the school of the audit of the education and manner of the operation to describe in detail such that the purpose will satisfy limited. Alright, example 5 the article state of the organization form of the charitable purpose without any further description such as the language and the sufficient sense of the term of the charitable generally accepted legal meaning. On the other hand, the purposes are stated with the charitable philanthropic benevolent organizational requirement won't be sensed for the terms of philanthropic benevolent have no general accepted legal meaning. Therefore, the stated purpose of the may under the laws of the state permit activities any broader than the intent of the exemption law. Example 6. If the article state or organization formed to promote the American ideal to foster the best interests of the people, to further the common welfare, and begin with the community without any limitation of the provision restricting such purpose, the accomplishment of the charitable manner, the purpose won't be sufficiently limited. Such purpose is vague and may be accomplished other than exempt manner. For example 7, a state purpose for the operating hospital does not meet the organizational testing since the necessary charitable. The hospital may or may not exempt depending on the manner of which it is operated. Example 8, an organization that expressly empowered the article to carry out the social activity won't be sufficiently limited to the power, even if the articles state that the organized will operate with exclusively in a charitable purpose. Dedication and distribution of assets. Assets organization must be permanently dedicated to dedicated to an exempt purpose. The means for the should be organizational dissolve. The assets for the distributive exempt purpose is described in the chapter of the federal government, state, and local government for a public purpose. The asset could be distributed to members of the private industry, but the other purposes of organizational testing isn't met. Dedication. To establish your organization assets permanently dedicated with the exempt purpose of the articles of organization contained the provision ensuring the distribution of the exempt purpose in the event of the dissolution. All relevant reliance can be placed upon the state that the law established for the permanent dedication of assets. Exempt purpose of the organization applicable probably can be processed much more rapidly, and articles of organization include the provision of ensuring permanent dedication of assets of the exempt purpose. Our distribution revision procurement in 82.2 in 1982 for January 1st, CB 3667. Identifies the state circumstances in which the IRS won't require express provision of the distribution of assets under the dissolution articles of organization. All procedures are sampled acceptable to the dissolution provision of the organization required to have one in the name of the beneficiary to be distributed. It may be one that would qualify and would be exempt with the meaning of the section 501c3. If the time of the dissolution takes place, and since the name of the beneficiary at the time of the dissolution may not be qualified, may not be existent, may be unwilling and unable to accept the assets of dissolving the organization provision that should be made the distribution of assets, one or more of the purposes specified in the chapter in the event of such contingency. Or sample or articles of organization. Sample articles of organization appendix in the back of the publication. Educational, organizational, and private schools. If an organization wants to obtain recognition exemption, the educational organization must submit the complete information as to how the organization carries on the plan to carry out the educational activities, such as conducting a school panel discussion, lectures, forms, the radio, television programs through various cultural media, such as museums, symphony orchestras, or art exhibits. Each position, you must explain where the activities were conducted, the amount of the admission fees, if any, of them may submit with pertinent contracts, arrangement, publications, programs, etc. If you're organized to conduct a school, you must submit information regarding the tuition changes, the number of the faculty members, the number of the full-time, part-time students enrolled, the course of the study degrees, and converted with together the copy of the school catalog and private schools discussed later. Alright, educational organization. The term educational rate, the instruction training of the individual for the purpose of improving and developing the capabilities, instruction of the public of the subjects and useful individuals beneficial for the community. Advocacy position. Advocacy of the particular position viewpoint may be educational, therefore sufficient, full, and fair. The exposition of the pertinent facts to permit an individual with the public to form an independent opinion of the conclusion of their member. Presentation of an unsupported opinion is an educational method, but not an educational method used to organize, develop, and present the view of the factors determining the organization qualifies the education with the meaning of the section 501c3. The following factors may indicate the method isn't educational. The presentation of the viewpoints unsupported of the facts, a significant part of the organizational communication. The facts support the view of the points are distorted. The organization represents making a substantial inflammatory, disparaging terms express the conclusion of the more of the basis of motion of the objective of the evaluation. The purpose of the youth isn't aimed to develop the understanding on the part of the audience because it does not consider the background or training. Expectational circumstances, however, may exist, whichever the organization of FSC may be educational, even if one or more of the factors listed above are present. Or a qualifying organization. The following type of organization may qualify the educational organization for the primary, the secondary school, the college. The following type of organization may qualify as educational. An organization starts with the primary, secondary school, the college, professional, trade school, has regular scheduled curriculum, regular faculty, regularly enrolled student body attendance in place where the educational activities are regularly carried on. Organizational activities consist of conducting public discussion groups, forums, panels, lectures, and other similar programs. An organization presents a course instruction with corresponding through the use of television and radio. Museums, zoo, planetarium, symphony, and other similar organizations. nonprofit children's daycare and/or credit council organization. College books and stores, cafeteria, restaurants. These are the on-the-campus organizations which submit the information show that they are controlled by the operated by the convenience of the faculty, student body, and whom they are controlled by the unserved. Alumni association. Alumni associations be established or organized to promote the welfare of the university of which they are affiliated with the subject and control of the university policy, the destination of the funds operated by the integral part of the university. Otherwise, they are organized to promote the welfare of the college, universities, and its association does not have the characteristics. It may be still exempt from the social club. As a social club, it meets the requirements as described in Chapter 4 under the 501c7 social recreation clubs. Athletic organization. The type of the organization may submit evidence to engage with activity such as directing and controlling interscholastic athletic competitions, conducting tournaments, if describing eligibility rules, the consistent contestants. If it is not engaged with the organization, may exempt the social club, describing the Chapter 4 rising funds of the youth, the travel to other activities, interview with the persuaded, prospective students, outstanding athletic ability attending a particular university does not show exempt purposes. If the organization is exempt as an educational organization, see amateur athletic organization later in the chapter. Alright, private school. Every private school filing an application for the recognition of tax exempt status must apply with the IRS for the Schedule B Form 1023 with the following information. The racial composition of the student within the faculty, the administrative staff of the current academic year. The information also must be checked over the more feasible the next academic year. The amount of scholarship, loan, and funds of any, if any, awarded student enrolled with the racial composition student that have received awards. A list of schools and corporations found in the board or members donated the land of the building, whether individual or organization. For a statement indicating whether any of the organizations were described in the theory above the objective of maintaining segregation, public or private school education at the time of the application filed, if there whether any of the individuals described in item 3 of the officer and active members of these organizations at the time of the application is filed. 5. The public school district is contained in county within the school located. How to determine the racial composition. The racial composition student of the body, faculty, administrative staff can be estimated based on the best information readily available to the student without requiring student application. Student, faculty, administrative staff submit the school information that school otherwise doesn't require. Nevertheless, the same in the method of which with the racial composition determined must be misapplied within identifying the individual students of the members, faculty, administrative staff to be included within this information. A school is a statement of a school that is a state municipal instrumental near beginning with the chapter were not qualified for the under section 501(3) is considered to be a private school for the purpose of the following discussion. Racial non-discrimination policies. To qualify the organization exempt of the federal income tax, private schools must include the statement, charter, bill, laws, other governing instrument with the resolution governing by that racial discrimination policy with the student that does not discriminate against the applicant student for the base of the race, color, non-ethnical origin. Also, the school must circulate information clear to state the social school admission policy, the national non-discriminatory policy towards students, means of the school admits for the student on any of the race of all the rights and the privileged programs, activities accorded made available to the student school. The school does not discriminate on the basis of the race, administrative, the education policy, admission policy, scholarships and loan programs, athletic or other school administrative programs. The IRS considers discrimination on the basis of the race, including discrimination on the basis of the color and national ethnic origin. Existence of the racial discriminatory policy with respect of the environmental faculty, administrative staff, and indicative racially discriminating policy of the student. Conversely, absence of the racial discrimination employment of the faculty demonstrated administrative staff and indicative of racial non-discriminatory policy of the students. Policy of the school that favors a racial minority group with respect to the mission, facility of the program, the financial assistance isn't discrimination on the basis of the race when, for the purpose of effect of the policy to promote, establishing, maintaining schools non-discrimination policy. The school that selects a student based for the membership of the religious denomination or youth until the discrimination membership of the denomination until the open to all the racial non-discrimination basis. Policy statement. The school must include the statement of the racial non-discriminatory policy brochure catalogs dealing with the student admission programs. The scholarship office of the school must include the reference to the racial non-discriminatory policy, written advisory, use to informing prospective students and program. Public requirement. The school must make the racial non-discriminatory policy known to all the segments for the general communication service of the school. The selection of the communication racial non-discrimination policy school provides solely related to the racial group when considered effective means of the communication make the policy known to the segments of the community satisfy the requirements of the school must one of the following two methods. Method 1. The school can publish a notice of the racial non-discriminatory policy with the newspaper general circulation of the racial segments of the community. Such publication might be repeated at least once a year during the period of the school solicitation student. In the absence of solicitation program during the school's registration period, when more than one community is served by the school can be published in notice of the newspaper that are reasonably likely to read in all racial segments and communities the school serve. Its method used notice must be the following printing requirements. It must be appear in the section of the newspaper likely to read the prospective situation. Students and their families must occupy at least 3 column inches. They must have the title printed at least 12 point in boldface type. Must have the remaining text printed with at least 8 point type. The following acceptance example is noted. Notice of the non-discriminatory policy as to students. The M school admits that the student of any race and national ethnic origin over the rates and privileges of the program, the activity general, according to the provided available to students of the school. It does not discriminate the basis of the color of the national ethnic origin, administrative educational policy, admission policy, scholarship or loan programs, ethical or other than school administrative programs. Method 2. If the school can use the broadcast media with the public side of the racial non-discrimination policy used to make the policy known at all segments of the general community school service. The school youth the message of the vote must provide the documentation showing what the means of the policy communicated with all the segments of the general community is responsibly expected the effective. In the case of the appropriate documentation would include the copies of the tape and the script that we used for the record showing that there was an adequate number of the announcements. The documentation also would include the proof that these announcements were made during the hours that they were likely to communicate with all segments of the general community and that they were long enough to convey the message clearly, that they were broadcasted on the radio, television, and likely to be listened to a substantial number of the members of all racial segments of the general community. The announcements must be made during the period of the school solicitation student, absence of a solicitation program during the school registration period. Art exemption. Publicity requirements will not apply to the following. If the proceeding of the year 3-year enrollment of the parish shall on the church-related school consists of the students at least 75% of the members of the sponsored religious denomination on the unit or the unit of the school can make it known as the racial non-discrimination policy whenever the newspaper circular religious denomination unit is used to use the communities if the students are drawn. The newspaper or circulars can be distributed in particular religious denomination or on the unit may be associated with represent the number of the religious organization, the same denomination of however the school advisory newspaper, the general circulations communities from which the student are drawn with except and second exemption discussed and that does not apply with the school that it must comply with either the public publicity and requirements explained earlier. Second, if the school customarily draws a substantial percentage of the students nationwide, worldwide, the large geographical section under the United States, the local communities, and if the school follows the racial non-discrimination policy as to the students of the school, may satisfy the public requirements by complying with the instructions explained earlier in the policy statement. Or the school can demonstrate the file of the racial non-discriminatory policy if they shown the currently enrolled student of the racial minority group with the meaningful number that exempt the local community schools. When minority students are enrolled with the meaningful numbers of the promotional activity, the recruiting of the absence of the geographical area of the responsible designated informed students of racial segment and send the general community within the area of the availability of the school. The question is whether the school demonstrates such policy to show satisfactory to determine the basis of the factor of the circumstance of each of the case. The IRS recognized the failure of the school drawing the student of the local community to enroll racial minority of the group, and the students may not respond to indicate with the absence of the racial non-discrimination policy, where there are relatively fewer non-such students in such the community. The actual enrollment, however, is meaningfully indicating the racial non-discrimination policy in a community which the public schools or schools become the subject of the desegregation order of federal court with otherwise express obligated to implement the desegregation plan under the terms of the written contract, other commitments to which the federal agency was a part. The IRS encourages schools to satisfy the publicity and requirement that using either the method described, even though the school considers itself to be one of the exemptions. The IRS believes that these public requirements are most of the effective method to be making the school's racial non-discriminatory policy in regard to each of the school responsibly determine whether either the exemption applies to such responsible will repair the school if it ought, but the IRS demonstrates the failure to public racial non-discriminatory policy accordance with either one of the policy requirements justified by one of each of the exemptions. The school must be provided with to demonstrate the public disavowed or reputed any statement purported to have been made on the behalf of after November 6, 1975. The contrary of the public of the racial non-discrimination policy of the student, the extent of the school, the principal's official will aware these statements. Alright, facilities and programs. All schools must be able to show that the program and facilities are operated in a racial non-discriminatory manner. Schools and loan programs, as a general rule, the scholarship and other comparable benefits obtained with the school must be offered on a racial non-discrimination basis. This must know throughout the general committee with the served in the school. That should be referred to them publicly. Financial assistance program, as well as the scholarship and loans made with the usual under the financial assistance of the program of the favor members of one more of the minority group that does not significantly detract the design and promote school versus racial non-discriminatory policy with adversely affect the school's exempt status. Our certification individual authorized to official action on the behalf of the school to claim that the racial non-discriminatory the students must certify annually under this penalty of the G and Schedule E of the Form 990, 990E, and Form 5578, annual certification of racial non-discriminatory private school exempt form of the federal income tax, whichever applies to the best of his or her knowledge, but the behalf of the school satisfied the requirements that applies to previously obtained. Failure to comply with the guidelines or order originally will result in the proposed revocation of the exempt status of the school. Our record-keeping requirements. Certain expectations given the later exempt the private school must maintain with the following record the minimum of the period of 3 years, begin with the year after the year of the completion of the acquisition. Records indicating the racial composition of the student, body, faculty, administrative staff each for the calendar year. The record sufficient for the document of the school scholarship of the other financial assistance award with the racial non-discriminatory basis. Copy of all the materials used with the behalf of the school solicitation contribution. Copy of all the brochures, catalog, advertising dealing with the student admission program, school scholarships, schools advertising national and large geographical segment of the United States need only to maintain the record sufficient to indicate what the publication of the advertisement is or place. Racial composition, student body with the faculty, administrative staff that determine in the same manner described and then given again with the section. However, the school cannot discontinue maintaining the school system of the record that reflect the racial composition of the student, the faculty, administrative staff used on November 6, 1975, unless substituted the different system to comply with the substantial same information without advance approval of the IRS. The IRS does not require the school release of the personal identified the record of the personal information exempt the audience of the requirements of the Family Educational Right to Privacy Act of 1974. Similarly, the IRS does not require the school to keep records of prohibited under state and federal law. Keep the records prohibited under state and federal law. Exemption. The school does not have to independently maintain these records. The IRS uses both in the following are true. Substantially the same information has been included in reports filed with the agency or agency in federal, state, and local government within the information is current within 1 year. The school maintains copy of the use of the report with the information ready to obtainable. If the reports do not include the information required to disclose earlier, provided that the remaining information must be maintained in school with the IRS use. Failure to maintain the records of failure of maintaining the procedure for the required records information upon prior proper request created with the presumption organization filed with comply with these guidelines. Organization providing insurance. Alright, we're going to go to organization providing insurance. Organizations described in Section 501c3 and 501c4 may be exempt from tax only if no substantial part of the activity consists of providing commercial type of insurance. However, the rule does not apply with the state-sponsored organizations described in Section 501c, 26, 501c, 27, which are discussed in Chapter 4, Charitable Risk Pools, and discussed in the next. Our charitable risk pool is treated as an organized operative with exempt charitable purpose that satisfies all the following requirements. An organized operative that only to the pool insurable risk for the members, not including risk related to medical malpractice, and provided the information of the members, the loss of control of the risk management, consists only of members that are Section 501c3 organization except the tax under Section 501a. Organized under the state law authorizing type of the risk pooling, exempt with the state of the income tax, and will be qualifying in Section 501c3 organization. Is obtained at least $1 million in startup capital with a non-member charitable organization. Is controlled by the board of directors elected by the members. Is organized by the document required that each member of the Section 501c3 organization exempt under the tax under 501a. Each member that received the final determination that is no longer qualifies under the 501c3 notifying the pool immediately. Each of the insurance policy is insured in the pool provided that it wouldn't cover events occurring the final determination described in B. Other Section 501c3 organizations.